Mastering Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions is applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subject being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions. In fact, that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by a recipient to another recipient requesting them, conditioned upon the fact that this notice is provided therewith. If you have any questions, you may contact Mastering Commerce by email at info@masteringcommerce.org.
So,
not a lot enough.
without contract, you don't have society. You know what I mean? You don't have a functioning society. And any time any leader has tried to take away contracting, that society lasts a very short time. It's crumbles within a very short amount of time. And everyone knows this. People who we would, I guess, call leaders, they know this. And in reality, you take away the capacity to contract and you take away all their power as well. Because anyone and everyone's power is derived from... Are we recording? Okay. Is derived from their power to contract. Plain and simple. How did the Rothschilds get the power that they have? Contract. Plain and simple. You know, so do you think they want the ability and capacity to contract to go away? No. Because they know as soon as it does, then it becomes power struggle. It becomes a fight. And whoever's got more guns wins. You know, then basically everything boils down to might. You know, and they don't want it to boil down to might, because when it comes down to it, who's got all the might? The people. There's 7 billion people. That's a lot of people. And if it comes down to it, we've got all the power.
All power rests in the hands of the people. The only thing is that powers that be don't want the people to get together and get smart enough to understand, number one, that they do have the power, but just power in and of itself, improperly used, is going to be chaos. So you have to understand how to use it in a manner which is acceptable under international private law dealing with contract.
I'm going to quote Stan Lee. With great power comes great responsibility. And he did that through Spider-Man. Right? Spider-Man had great power, and the realization was with great power comes great responsibility. And that's what we're teaching. That you have this great power, but with that power comes a great deal of responsibility. And until you're ready to step into the responsibility part of it, thank God we have the gatekeepers who will make sure that society runs and functions. Because that's, in a republic, which is what we supposedly have, that's the only thing keeping us from absolute chaos is the judges. You know, the judges is what it comes down to. And even in the days of Moses when they were without a king, what did it come down to? The judges.
If you go back to the Old Testament in the book of Judges, and you start reading the introduction, it'll tell you at that time in Israel, all they had was the people, and everyone was doing his own thing. And so why did they instill the power and office of the judges? The judges were the trustees over the people who were just doing their own thing. And if you think people doing their own thing always get it right, they never do, especially if they're uneducated. So why did the land of Israel have the power of the judges before they got the office of the king? Because the judges were the trustees to keep the people in the land from sinning so much that God would bring a judgment against the land. What do you got in America today? Don't you have people basically doing their own thing? But we have superimposed in America a judicial system. Let me ask you a question. Is this judicial system anything like the original office of the judicial system under the Constitution? No.
Well,
These judges are under
there.
what?
There's a legislative court and a judicial court that are happening simultaneously. Now, most of the time you're in court, you're under a legislative court, which there are no judicial determinations in a legislative court. Only administrative determinations are made in a legislative court. Why is there a legislative court? Because a majority, 99.9% of what's happening is under statute, which is legislation.
And the statutes are the rules of the democracy,
The corporation
which
itself.
is an overrun government, overrun by the military, to which the commander-in-chief president is the head of the military. So you do not have an independent judicial, you've got a court-martial judicial operating under the democracy. You do not have an independent legislative. You have a legislative advisement to the democracy run as a military government. And so everything is administrative process. They're basically trustees to do what? They keep the people who are doing their own thing in line. So we're right back to where we were in the Old Testament again. Nothing changes. History just goes around and around.
But when people step up to be responsible and to operate under the common law and under private rights and remedies, the judicial, it's as if it comes to life. And I don't know if all judges understand this, but I think a lot of them do, that they play a dual role. That they play the legislative, where they make administrative determinations, but when called upon, they can make administrative or judicial determinations as well. I think we see most of the judicial stuff happen in what we call in chambers. So it seems to me that if there were two sides to the court, what's happening in the public, what's happening in the courtroom when the judge is in his robe is administrative determinations, legislative court. What happens when the judge takes off his robe or you meet in chambers is judicial determinations. So you've got access. But in order to use that side of the law, so to speak, or that side of the court, you have to demonstrate that you operate responsibly in the republic without the franchise, without the benefits, without the privileges.
Aren't all those benefits and privileges, that's just another contract we've gotten ourselves into, right? Mm-hmm. And they know you're in this contract when you go in there.
Well, they don't know that. They presume it.
Well, it's already under presumption, right?
Yeah. Like, for instance, if I were in court and they were to bring up, let's say they have some kind of a master record of the straw man named Brandon Adams, what they would see is that has no property, doesn't take any sort of benefits, doesn't pay into any kind of a benefit system, right, is basically by record doing nothing. It doesn't exist. It doesn't have a driver's license. It doesn't operate in their world of commerce.
But the regular guy, he's like me.
And that's actually what we're going to get into right now, are the hats.
Driver's license and, you know.
And there's nothing wrong with that, because there's a way to be effective in commerce while wearing all those hats. You can still operate a straw man. It's about understanding who you are so that you are truly operating it as if it is something separate from yourself. The problem is when you believe that you're a name. And I don't care how the name's spelled. I don't care if it's uppercase, lowercase, hieroglyphics. It doesn't matter. The name is always a fiction. Whether that fiction is a franchise of the United States or whether that fiction is a privately generated entity is to be determined based on what? Your actions, your conduct, how it's expressed in contract. Right? Like when I write a contract, it's very clear what entity you're contracting with, that this entity is not a franchise of the United States, that by even being in contract with the entity, you're waiving any and all franchise benefits, privileges. Okay? So there is no limited liability in this contract. Okay? If you're entering into this contract, you're doing so without that straw man, so to speak. I don't care what name you want to use in the contract, but we're clear that in this contract, that franchise is not allowed. Meaning, if there's any dispute in the contract, I've spelled out how the dispute is to be handled. You see, because one of the benefits and privileges of operating that franchise is that you've got the disposal of the court system to handle any contract disputes, right? But in the private contract, I've spelled out that that is not an option. That the only option for dispute resolution is a private dispute resolution process through a private court or third party, whatever it is. But by entering into the contract, you've agreed to that. So just like your landscaping contract, if it was expressed and spelled out that we're not operating under franchise, that we're expressly operating under whatever you want to call it, under common law, private international law, right? You guys have seen the governing law clause in contracts, right? This contract shall be construed and enforced under the laws of the state of California or under the laws of the United States, right? It's setting the franchise. It's saying that this contract is protected under this franchise. And what do they do in the initial pleadings of a court case? Right, they'd say what the name is, that this person is a resident, right, of the state of California.
So the name is a franchise.
Okay, so they're spelling out that showing that the court has jurisdiction. Because if you weren't a resident or a citizen or anything else, the court would have no jurisdiction. Because that status of resident of state of California is something that falls under the Superior Court of California's jurisdiction. If you weren't a resident, or if the property wasn't in the state of California would have no jurisdiction, right?
They're talking about a straw man.
Right, but that's what you're there for.
They're talking about the straw man.
That's the only thing they charge. If you didn't use the straw man and didn't have a driver's license and all those other things, how could they make you the same as the straw man? Why would you care what they were charging the straw man with? The fact is, you got bank accounts, you got property, and you got all these things in the name of the straw man, so you're using it. So you show up because you're freaked out. You don't want them to charge the straw man because there's all this stuff that you've got under the straw man that's in jeopardy, isn't it?
But you could show up as the accommodation party.
Right.
If you show up as the accommodation party, are you under those jurisdictions or any of those presumptions that are in the leading paragraphs of their court case? Not unless you want to be. Okay, so you're totally alien and foreign to anything they've just said. So the issue is, what's your point? We're here to set off the case.
Okay, so let's look at the different hats, so to speak, that we wear in relationship to this straw man. Because this straw man is a corporation, or trust, put it simply. It's a trust formed under the franchise of the United States.
Yeah, trust is to reality. A lot of patriots are trying to file 1041 tax returns on the straw man, but that's too much reality for them. They don't want to see that.
They've already got a special class. They realize it's a trust, but they have a special class of trust that they call individual. Mm-hmm. And an individual is a special kind of trust that files a 1040 form. Okay? So, in tax code, this trust is known as an individual. Okay, individual taxpayer. Now, explain to me, Jack, the accommodation party.
Well, remember in Scripture in chapter 4 of Genesis, you have the first tax protester, and that happened to be Cain, because the sin in the Garden of Eden was reckoned as a debt. And so Adam and Eve were told at the tail end of chapter 3 that they had a debt. And they realized when you have a debt, you got to pay something on the debt. And if you can't pay it all at once, you got to pay it every moon, which is every 30 days, every month. And at first, remember, Adam and Eve said they were naked and they covered themselves with leaves. But at the tail end of chapter 3, the Lord said, no, that's not the money of account. And God slew animals and gave Adam and Eve the pelts, skins of the animals as a covering. The blood of the animal was the money. And the pelt, now, the dead animal, is the receipt for the payment of the tax. And remember, if you've paid a debt for the month on an installment, you say you've covered the debt. So the nakedness was, in essence, their understanding that they no longer stood with God, they were separate, and they needed a covering every month, a receipt for a payment of an installment. Now, since the blood was the declared money, you had two offspring of Adam and Eve, one called Abel and one called Cain. And in chapter 4 we have the first tax protester, because the Lord went looking for Cain and said to Cain, what the heck are you doing? You are not paying your taxes, i.e. your debt installment, properly on a monthly basis. Now Abel raised animals, and he made a sacrifice of the animals to do his monthly payment in blood to God. And it was acceptable. But Cain was a farmer, and he decided that when he went in to pay his mortgage to the bank, he was going to take some fruit and vegetables in. And the Lord was coming to him as the banker saying, that's not legal tender. I cannot accept your payment. And Cain is arguing with him. And the Lord said, unless you give me blood, you haven't made your payment. So Cain goes out, slew his brother, and gave the Lord his brother's blood, which is now compounding a lot of problems, because number one, you can't take property from your neighbor to pay your debts. It's called theft. Secondly, thou shalt not kill. You don't have the right to take the life of your brother. But the point is, the Lord said something about, are you not your brother's keeper? And if you've seen the movie Cloud Atlas, you will know that they're saying that every event that happens, civilly and criminally, affects every one of us, because it ripples on in nature and causes all kinds of problems. We are our brother's keeper, which means that we have to accommodate our brother. If you see he has a debt and he cannot pay it and you are his brother, if he asks you and you can help him, you must do so. Now, our straw man are not technically our brothers, they're fictions. But nevertheless, you helped create them through that grantorship role. And whatever you've created, you're responsible for. And because you have created him and he's gotten himself in trouble, you have to deal with the trouble that your creation has caused. And if you don't deal with that, then you're held accountable. How many people saw the movie Prometheus? Do you remember in that story, which is the prelude to, or prequel to the movie Aliens? And Aliens was out like at the end of the 1980s or something like that. And this movie is a prequel to it. It dealt with a corporation on Earth sending a spaceship way out to investigate. The first one, Alien, was a derelict spaceship. And the crew was supposed to meet with this, transfer the cargo on board the derelict spaceship and bring it back to planet Earth because the corporation wanted to retrieve it. It turned out to be that alien monster. The reason that the corporation wanted it is because it was so dangerous they wanted to turn it into a military weapon. And you saw what it did. It just about wiped out everybody on the voyage except the captain. Prometheus is a prequel in which there is a story of the same corporation sending out a mission about 30 to 40 years prior to the mission for Alien. And they went to a far distant star system, probably under Orion, because they believed that the gods, they called them the architects, that had created life on planet Earth. They came down to Earth and seeded life, then abandoned their creation. They believed that the architects, once they got up to Prometheus to investigate this, were coming back to planet Earth with the goal of exterminating all man life on Earth. And the question that they posed in the movie Prometheus was, why would the gods that created life on Earth want to come back and kill us? Just go to the Scripture. Did not God create man and put man on Earth? And later on, he looked down on Earth and he said, look what kind of a problem man is doing down there. We've got to wipe them all out. If you create something and it gets outside your control, you're responsible for it. Now, what God ended up doing is he came down and wiped out all of mankind except for 8 people who were on the ark. 8 stands for new beginnings. They never answered the question in the movie Prometheus why the architects would want to come down and plan on wiping out life on Earth. But we already know the answer to that, and in the movie it gives them an excellent opportunity to have a sequel to the prequel. But the point that Hollywood is making is, as a group of 7 billion inhabitants on planet Earth, aren't the majority of the 7 billion so incompetent that they can't handle their own affairs, let alone get along with each other? Isn't there right now a public monument in the state of Georgia that's been there for a period of time, which has literally said that the destiny of mankind should be a society of a balance of around 500 million people and no more than that? We can't even fix our own problems, let alone be our brother's keeper. But we are told by accommodation that we must look out for our brothers. But if we can't even look out for ourselves first, there's a fat chance that any of us are going to be looking out for our brothers. But they've given you a perfect metaphor here. Even as mankind who fell into sin has no capacity to set off that debt, because he has no currency that can be used to pay the account. You have to have a lamb that has blood and is an innocent lamb, having never sinned, to have the lawful money of account to pay off the debt. In what man has not sinned, other than if you believe the Scripture, there was one that came to life without sin, and his blood was shed as the de jure money, not a de facto money. Because the sacrifice of the animals all the way through the Old Testament was a de facto money. It didn't pay the debt, it was symbolic of paying the debt. Had it not been for Jesus, the accommodation party for the rest of us, there would be no plan of salvation in the sense of the biblical telling you about debt and redemption. Your straw man was created in sin. I mean, he was not given access to anything except public debt. You can't pay off public debt with public debt. That's called a novation. It is not called a payment. So unless the living man who has the capacity to get the money that is equivalent to asset, having both legal and equitable title to its units, comes in as an accommodation party for his own straw man, there is no ability to get your straw man out of trouble because there is no remedy in the public. You've got to go over to the private side in order to get your asset funds to have that remedy. So everything that we will be teaching you in terms of a remedy, in court, in your private administrative process, personally knowing, as I came up here after lunch here, one of the gentlemen said to me, so let me get this straight. You're saying I can just write another promissory note and get my remedy? And the answer is absolutely yes, if you're writing that promissory note as an accommodation party creditor, not as the straw man. So what Brandon is taking you into right now is the absolute foundation for all remedy. You've got to get back to the equivalent of the lawful money, which only comes from the private side. And your only remedy is to deal with these accounts by what is called accommodation. And in the Uniform Commercial Code, you'll see it under 3-419. And that gives you the right as accommodation. And you got to understand that if you're going to accommodate another party, you as the accommodation party are getting no direct benefits. What that means is you can't own what it is that you redeem for your straw man. Only he can own it, but you cannot, because ownership is debt. And you're not doing it to claim anything other than to help your brother.
So what is an accommodating party? Does he represent? What does represent mean? What's that? Represent. To present again. So is an accommodating party representing, or even have the authority to represent the debtor? No. Okay.
In commerce, if you present someone, who are you presenting them to and for what purpose? You're the subject or the servant. You're being introduced as the servant or subject to the sovereign. You don't want to be presented. You are who you are. And as if you believe that you have the capacity of a sovereign, you're not presented to another sovereign. You might be introduced to another sovereign, but to be presented or represented, represent means you're being brought back from having not been the subject, and you're now going to comply and be the subject. Remember, an attorney represents a client. Or the court says, would you like to represent yourself? No, not really. I am who I am. I don't want to present any fiction back to you and become the fiction. So the answer to the question is the accommodation party is not representing anyone.
So that's an important distinction, so that you don't make the mistake of having that in your language or in your thoughts. You are not representing, or the accommodating party is not representing anyone. So if the accommodating party is not representing the straw man, what is the accommodating party?
The agent for.
The agent for what? What's that? A provider pays? Okay.
Is he taking the liabilities on behalf of?
Is he taking the liabilities on behalf of? Okay? Becoming a surety for the liabilities. So what is the relationship? What makes sense? If we're going to be an accommodating party and we're going to be discharging or setting off debt of the straw man, you're doing something.
You're doing something on behalf of the straw man.
Okay, so you're acting.
You're acting.
Okay?
So the good example for is like, let's say I'm a mother paying on behalf of my daughter. I'm taking the full responsibility of the debt. You know, I'm being liable or becoming a surety of my daughter who's going to have the ownership of the car, for example, but she's not going to be liable. That would be the example. So I'm being the accommodation party for...
So as the accommodating party, do you have the liabilities of the party you're accommodating?
No, you're assuming the liability.
Assuming the liability.
Are you assuming the liabilities? Or do the liabilities remain with the party you're accommodating? It remains with the party you're accommodating.
So, wouldn't you be like a trustee? In some sense?
Tell me more. What's the trust?
The trust would be a private, there's two trusts, right?
Well, there's
Well, there's
a lot of trusts.
I mean,
There's a lot of trusts.
in this particular capacity, there's like two trusts, right?
What would be the corpus of that trust?
Of the private trust?
What property are you putting into that trust that you're just describing?
That'd be the body.
What body?
This body. No?
No, there's another trust that holds the body. What
That's the
property
public
are you
trust.
putting into this trust
Oh, that'd be
that you're
the
creating
estate.
by accommodation?
It'd be the estate,
What estate?
the private asset estate.
No, it's already in another trust.
Okay, then I'm talking.
It was in
thinking-
the Social Security trust.
That's in the Social Security.
What are you transferring into this trust? See, you said trust, and Brandon picked up on that, and he's got this aha moment, and he's trying to get you to think of how many elements are in the trust.
Well, there'd be substance. What's the substance, right?
Well, there's a grantor, there's a trustee, there's a beneficiary. Describe that, but then the trust doesn't work unless you put some property in there.
You don't have a trust.
What property is going into this trust that we're dealing with by accommodation?
The account or the time?
The debtor account. If he owes a tax, this accommodation to pay that tax, the property going into the trust is the debt account for that tax for that taxpayer. So it's a straw man's taxpayer debtor account. That's the property. Okay? Who was the grantor? Who is the trustee? And who is the beneficiary?
The beneficiary is the straw man or the creditor, and the trustee, the grantor would be the accommodating party.
Just guessing.
Okay.
Close?
Close. Anything with a name or a unique identifier, by definition, is a trust. So even an account, like for instance, federal court case number 3:2012-6635. That's an account, and there's a trust. If it's got a unique identifier, there's a trust to it. Okay, so the straw man, does he have a unique identifier? What is the unique identifier? The name
The name's
with
the
the
date.
Social Security number. So that is a trust. The debt accounts. What debt account are we dealing with?
There's a court issue.
What's that?
There's a court issue or
We could do a court issue. The case number. Okay, so there's the court case becomes a debt account. Okay? So as the accommodating party, where do you fit? What is your relationship to the debt account and the straw man? Well, here, let's first, what's the straw man's relationship to the debt account?
Would they be the grantor?
Could he be a grantor? Who's got duties and obligations in a trust? The trustee. So, what's the straw man in the debt account? Initially, he's a trustee. What happens when a trustee doesn't perform? A protector steps in, right? Who's the general public protector? The judge. Okay, so, but what if someone steps into this abandoned role? Now, can the straw man, who has no lawful money, who has no assets or property, can he do anything with the debt account? He can't settle it, right? He can't set it off. He could take a benefit and privilege and go to jail. But who, in that scenario, who's settling the account? Who's taking responsibility to settle the account? The judge.
Protector.
The judge is taking responsibility to settle the account. Okay, so if we don't want the judge stepping in and settling the account, what does the accommodating party need to do? Settle the account. Step in and settle the account. Right? So what role would you be stepping into? Trustee. Okay? So the accommodating party steps into the role of trustee for the debt account.
So the accommodation party is doing in private what the judge of necessity is doing in public if the old trustee, the straw man, stands back and does nothing. And so you can settle it privately, or you can do nothing and settle it publicly. But you can't settle it through the old trustee, the straw man. You have to have a protector, an accommodating party.
Okay, so now we also use the term often of paramount security interest holder. What does that term mean? Paramount security interest holder. What is a security interest? It's a lien. What do you mean by that? What is a lien? A claim? A claim to? A right to? An interest in? Right? So, what is paramount? The highest, superior, priority over all others. Now let's think about the trust that you're currently engaged with now. You talked about a body being in the trust, right? The physical body. Who's the paramount security interest holder? Are you sure?
Well,
when was their what was their date and time of their claim? When the birth certificate was registered. Right? Are you dancing for some reason?
Yeah.
What is my microphone's on? Oh, you had an answer? You had an aha? Oh, the I. Okay, so the I, the true you, which isn't the body. You're not the body, you have a body. Right? Who are you?
life force.
Who are you? Are you sure? Because I would say you have a soul, but you're not the soul. The soul is an aspect of you, something you have, just like a body, just like a mind. You have a mind. Are you your mind?
Yeah,
No.
Body, soul, and spirit. The body is the physical. The soul is the animating life force to the body. because when you are deemed to be a dead body, it's said that the soul has departed from the body. The life is in the soul. So the soul is the attribute that gives life to the body, but it's still not you. You are the spirit.
Is there an answer to this question? Who are you? Who are you? Who are you?
I've never seen my spirit. I can't describe it. All I know is I am.
So, and that's an interesting analogy that they even use in Scripture of the I am and the ineffable. Because there's an element of you that can watch your thoughts, that can experience emotions, that can experience the physical body. So it's none of those things. If you're observing thoughts, which you can do, can you see your thoughts? Can you hear your thoughts? Can you watch your thoughts? Yeah. There's an element of you that can actually observe the thinking element, which is the mind. So it's not you. There's an element of you that can experience emotion. The emotions aren't you. There's an aspect of you that experiences the body. That's not you. Now, this is an esoterical conversation. And this goes deep in all religions and philosophies. The who am I? Who are you? And the minute you label it, that ain't you. Because anything you label, soul, body, mind, emotions, anything that you label is now content, not the context. Does anybody know what I mean by the distinction between content and context? Okay, so what is the context of this training or of this workshop? That's content. What is the context? What's that? Energy? That's content.
It's just before, that moment before you think it is, that's content.
That's content.
The room? Tables? Yeah.
That's content. Tables are content. Content. Learning is content. Becky? No thing. But you just labeled it, so you just made it content. See the problem we have here? As soon as you start to label it, that's not what it is. Because you're more in the sense of context of being. Now that I've labeled it, it's not that either. But that's essentially what we're getting at is you, in your truest form, are the context of being, which includes a soul, it includes a body, it includes an emotional experience, it includes everything that you can label and observe. Yet, that which observes and makes distinctions is the context. And then as soon as I label it, it becomes content. So, any name is a fiction. So when I said, who had paramount security interest in the body? And you said, I do. And I said, well, who are you? I'm not doubting that you have the paramount security interest in the body. Because let's face it, you were there first. Right? You were there first. So if you were the first one there, in the body, of the body, connected to the body, having the body, so you had first claim to the body. Okay? So, and from the body, we have labor, right? We are behind moving the body. We're behind creating with the body. So we're behind generating with the body, correct? And we generate with the mind. So the I, that thing that can't be labeled, has an interest in everything generated and created through the mind, body, spirit. Correct? So first claim to all of it. So when the straw man gets introduced and property starts being generated through who has the interest in the labor? I do. And so I have first claim to all the property that gets placed into this trust, don't I? And remember, we were talking about security interests earlier. Does my interest ever go away? No, it's always there, but I can assign it, can't I? And so what happens is interests of our labor, interests of the body, all get placed into this trust. Right? Or in trusts like it. Because if we're talking about the straw man as the Social Security Trust, there was a trust that existed before that got into a contract with the United States to create this. And that may be the trust that the body is in. Because the first trust was created when your parents said, oh, I'm going to call it Brandon Alexander Adams. They gave it a unique identifier, didn't they? And if you look at that life, you could look at, in that trust you had God, that force that creates, as the grantor, mom and dad as the trustees, right? And the world as the beneficiary. That was the first trust. We can call that the origin trust. So it has this unique identifier. And a lot of times we make a distinction of this trust. We call it the living man. But it's a fiction because you gave it a name. But your implication of calling it a living man, and I've heard people say flesh and blood, living man, right? Is that it was the origin trust in which the body was placed. And you've taken on the role of trustee for. So are you the name? No, not in any form. Mom and dad gave it a name. And you decided to operate in commerce through that name. And the first contract you got into created this franchise. So the body was originally in that trust, the origin trust. Does it ever give up its interest in the body? No. So now we've already got, before we've even made it into public commerce, we've already got two trusts. And then this trust was created. And an interest in the body was conveyed. How do I know that?
Because of the certificate.
What's the evidence of that? Birth certificate? What else? Well, that was on the application for the birth certificate, right? So you're placing the body into a trust, right? And so you had to identify the property, right? Just like we need a VIN number, right? We need a VIN number to put the car into a trust. What do we need to put the body into a trust? A unique identifier, right? Unique identifier, right? So footprints are a unique identifier. And then it gave it a name. This is before there was a number. So that's another trust. And then that trust contracted to create what the trust that we deal with the most in public, which is that trust with a number. It's got the name, all capital letters, and the number. Unique identifier. So there's already been a conveyance of interest in the body at least 3 or 4 levels before we get here. And then, if we're going back to this being a court case, well, let's say it's a criminal court case. If you're found guilty and sentenced to 7 years in the warehouse, has there been another conveyance of interest in the body? right? Into this trust. And then is this trust revocable or irrevocable? It's revocable. Even if you get life, it's a revocable contract. It's a revocable trust. Because this trust is a revocable trust, isn't it? And so is the birth certificate trust. That's a revocable trust. Now the origin trust is revocable. It's just, do you want, may be difficult for some, maybe for others it's easier. But it's revocable. It can terminate and be terminated intentionally. That's revocability.
Would you be willing to take a moment and go back to the first trust you're aware of, and just kind of along the timeline of a man's life, or even predating his existence due to other contracts that are in place and that he kind of steps into through his parents or whatever?
Right.
Well, nobody can contract for you other than you unless you're incompetent by way of age or disability. So anything that existed before you were born into the world actually doesn't influence you in terms of the worldly things. The only contract that deals with you before you were born into the world that you got to deal with is part of the origin trust with God, because you were born into the world with what is called inherited sin. And that just means inherited debt. It didn't mean that you came into the world and you didn't even commit a murder or theft or anything. It meant that it's implied upon you. Because understand this, under the law of debt, whatever collateral belongs to the debtor until the debt is discharged or paid is included within the estate to pay that debt off from the beginning. And so Scripture defines the spiritual thing that brought you into the world with a disability is that our parents, Adam and Eve, fell into debt. Did they ever pay their debt? Ever. Not of themselves. They needed an accommodation party, right? Okay? So because the offspring of the man is his property, all future generations are under his liability to pay that debt. So original sin or inherited sin is nothing more than being described as, we don't care if they're unborn and born into the future until somebody pays off Adam and Eve's debt. They're still collateral that are under debt, and hence they're under original sin.
And let's look at the body itself. You're borrowing the elements that make up the body. It's borrowed property. So there's an implied debt because you didn't bring the materials of your body into the world with you. You came into the world, inhabited the body, and are temporarily you're constantly borrowing from the planet itself to maintain the body, aren't you? When you consume food and it breaks down to make up the rest of your body, you're borrowing it.
Now when you look in terms of things that are going on in this world is the world of the fiction and the government and the bankers. The world is reality. So we can talk about the world and this world. They had no contracts on anybody in the world. It only comes on you as you come into this world. See, the whole reason why the abortion program is what it is because until you are born and registered, the government can claim no property rights on you. So that whole history of abortion, the question that was asked in the abortion bills in the courts were, could the woman have the right to determine what was going to happen to the issue of her body as far as this world, the corporate state, was concerned? And what the judges went back and said, we don't have any contracts on the fetus. We don't have any contracts on the fetus until we get the hoof print after it's born alive.
Hoof print.
So it makes never mind to us what the hell goes on. It's outside our jurisdiction. So in essence, they did a confession and avoidance. We're not going to say it's legal. We're not going to say it's lawful. Well, we're not going to say it's right or wrong or lawful. We will say, as far as legalities are concerned, since nobody's got a claim on it, we could care less what the hell happens to it. You see what happens? And it doesn't say it's right or wrong, morally right, morally wrong, or anything else. See, in Scripture, in most religions, the Lord said, I knew you from before you were even conceived. So in that
So that's where the
world,
original contract is made. Before you were conceived, there was the contract.
You got it. But not in this world.
Origin.
So if you're going to talk now about how did the corporate state get involved in any of these contracts, it didn't get involved into the contract till a baby came into the world. It wasn't yet registered, so they couldn't deal with the baby. But was the mom registered? You bet. She was one of the slaves on the plantation because she was registered. And any time the plantation had a birth, it was property, and who'd the property belong to? Belonged to the plantation. So you had a birth through a registered mom, and now they go to mom and say, you have anything announced to the plantation? Oh yeah, by the way, there was a property delivered to the plantation. Well, let's go ahead and register it then. You see what's happening? So they didn't bring anything on you until your mom registered you in this world. And as soon as that happened, they're just sitting back for 18 years to see what you're going to do about it, because they got to get your consent to ratify what your agent, your mom, did with you. Because everybody is born into freedom and opportunity, unless, of course, you want to give it away pursuant to Exodus 21:5. If you love being a slave, you can go in front of the officials and say, I want to be a slave, and they will allow you to be enslaved. So at age 18, you got a 30-day period to be enslaved. Now, when mom registers you, like Brandon said, she registers you under a name. That name now becomes the property description. And who is the holder of the use for that name? Who's got the rights to it?
Who'd you register it with?
Yeah, whoever it's registered with.
Think about this. You guys ever heard of the term in persona conjuncta? In persona conjuncta. It is a term used in trusts whereby, or it's used beyond trust, but specifically in trusts, the trustee has all the rights and powers of the trust itself. So, in mom applying, right, asking the state to be trustee, basically said the state has all the rights and powers of this name, because the state is the trustee. So when you go in there and you think you're Brandon Alexander Adams, you're having an identity crisis. Because it's the state that's Brandon Alexander Adams.
It's the plantation's property description, and it belongs to the plantation. Doesn't belong to you. So if you're looking at the Patriot Redemption Manual, there is some errors in there, because they're going to tell you in there what you need to do is go copyright that name. Excuse me. You don't have the rights to that name unless you're going to do something to gain that trust back, because the trustee, the United States, has the rights to that name. So the biggest problem you're going to have if you copyright that name and try to charge the state for using that name on documents, they're going to come after you because you're a claim jumper. It's their claim, not yours. So you don't want to do that. They've got the first name, the middle name, and the last name. That's copyrighted. But see, under the common law, that's not even your name in the common law. In the common law, dealing with the first, middle, and last, what is your name under the common law? First and middle. That's it. The last name is not part of your name under the common law. So what the state is copyrighting is they're copyrighting what you think is you, but it's not you. If you
Never
went back
was.
to using just your first and middle name, they haven't got a copyright on that. And if you go into court and they say, "Are you Leslie Jack Smith?" I would never testify and say, "No, I'm just Leslie Jack." But if I did that, they can't recognize a Leslie Jack because it's not registered. But they can recognize a Leslie Jack Smith. Now, how many people in here have filed a UCC-1 to try to get their own identity? There's some of you, okay? Have the rest of you heard of that or not even heard of it? How many have not even ever heard of doing that? Okay, there's a number of people in here, okay? Remember, the UCC is where you're filing private claims. And if you're trying to get your freedom and liberty back, whatever that means, there's a lot of patriots out there that are going down and filing UCC-1 as the first part of their process on what generally is called redemption. And in order to file a UCC-1, you've got to have a debtor and you've got to have a creditor. And they use the name debtor, Leslie Jack Smith, all caps. And then they try to use the name creditor, Leslie Jack Smith, upper and lower case. But in their system, every name is all uppercase. So even if you did that on your app, when anything comes back from the Secretary of State, they're going to look the same. They're all caps. Because caps are fictions, dead things, which is what a person is. It's a dead thing.
Which is what anything in commerce is.
Because it's Admiralty commerce.
Anything with a unique identifier, a name, a title, is a fiction. So in their world, or this world, every fiction is an all uppercase appellation.
Because that's the names on the backs of ships going to sea, vessels. They're all feminine. Admiralty's feminine, and it's all caps, whereas masculine or law of the land is proper upper and lower case. So all your name is a registered vessel in commerce operated under Admiralty Maritime. So it's all uppercase. So how do you get around that? Well, if you were to put in on the fiction or the debtor, Leslie Jack Smith, but under the creditor you were putting in Leslie Jack, they got a box for a suffix, don't they? Put of. And then the last name, Smith, starts with a little s, M-I-T-H. Leslie Jack of Smith, is that the same copyright name as Leslie Jack Smith? No, it's different. They don't recognize it in their system as being the same name. So therefore, if you try using the way most patriots do to begin with, and just upper and lower case the creditor name, the Secretary of State many times will write back and say, "You can't contract with yourself. This is an invalid filing. Hasta la vista. We're not going to file it." And many of them don't get filed. But there's ways around it by understanding what is what and what is proper. And they get it done.
And what names you want to have your interests in. We call this the name game. A lot of our clients get caught up in the name game. And oftentimes it becomes the biggest obstacle to getting any kind of a remedy or result for people.
First thing the judge does when you go into court on a criminal case is, what is your name? Sir, what is your name? Are you, if the defendant's name is Leslie Jack Smith, are you Leslie Jack Smith? And as soon as you say, "Here and present, Your Honor," you're the debtor. You just screwed up the whole case. You can't respond to the name. If you become the name, you are the debtor. If you're the debtor, you're not the accommodation party. If you're not the accommodation party, how are you going to win this case? So the judge says, "Who are you?" "I'm the accommodation party, Your Honor. May we proceed?" "Well, are you Leslie Jack Smith?" "Your Honor, I told you I conditionally accept your offer to qualify beyond the fact that I am the accommodation party. Is this court maintaining an obstruction of this case, or are we ready to proceed?" He asked, "Who are you? In what capacity are you here?" If you give him the name, what capacity are you here when you answer to the name?
Defendant.
You're the debtor. You just lost your case.
Could you do the first name hyphen, middle name, colon?
No, they're going to go that, well, it's a bunch of crap because the last name is still the same as it was before.
That's the quantum way of writing the name. But when the rest of your document is fictionalized, what use is the name in quantum?
Okay.
I have a huge issue with that because I see patriots doing it all over the place, putting their name in quantum. I don't even think they know where it came from. They just saw someone do it, and so they thought, oh, well, that means the living man. No. It's still a fiction. It's just because it's a noun, you compound a noun with a hyphen. So, Brandon Alexander. Brandon hyphen Alexander is one thing. Just like he was saying, Jack Leslie. It's one thing. The colon signifies of the Smiths. Or of the family Smith. That's what the colon means. That's what the symbol the colon means. Example, of, as. Okay? So that's why the name is written that way. It's a proper way to create that noun. And a noun is a no. If you look at the word noun, it's N-O-U-N, which is a no, and then un is no. So it's a no-no. What happens if you have two negatives? It's a positive. It's a thing. A noun exists. It's real. Okay, now we're not going to go too deep into quantum because the place where quantum language falls apart is the maxims of law. Maxims of law state that the intention is the soul of the instrument. The intention is the soul of the instrument. So the fact that none of us know how to properly write or speak English is immaterial and irrelevant. The intention is the soul of the instrument.
When you put that name in there, like in quantum or in reality, in their courts, they can't see anything living, so you're not there. So it's a failure to appear. They can only deal with the fictions. So when we're coming in there as the accommodating party, that's why they will not want to talk and respond to us, because we are the accommodating party. The only reason we can get by with being the accommodation party is because we're probably the only one there that truly has a claim. And they cannot prevent a claimant from being there as long as you do it colorably enough to be able to make it work. See, they summonsed up. Remember, summons, isn't that something you do like when you go to a seance? And if you're going to summon something up, are you looking for reality or are you looking for something that already died to come back and do something? So when they put out a summons for your straw man, isn't your straw man dead? And so they want him to reappear at the hearing to help them screw up the estate of the straw man. So they're really calling a seance in their dead courts to have the appearance that something real is showing up when we're not going to deal with him anyway, because since he's dead, every court is a probate court, and who the hell's going to take any testimony off of the dead? You'd be insane to do it. That's why you can't win in the court when you do appear as the dead thing, because you are dead. It boggles your mind to believe that they can get away with the insanity and the crap on us, and we don't even question what the hell is going on. So just take it from us, you cannot win by answering to the name, no matter in what capacity it's in. All you want to do is appear as the accommodation party, and if they intend to deny you, then counterclaim them for obstructing justice and denying justice and equal opportunity. Because if you are a registered accommodation party with a registered interest, they cannot ignore you.
Then if you state to the judge that, introduce yourself as accommodation party Leslie Jack Smith for the defendant Leslie Jack Smith.
I'm not an accommodation party for him. I'm accommodating his account.
Okay, so how would
Otherwise,
you
they'll
put that?
assume I'm representing them.
Remember what the accommodation party stepped into? Trustee of what?
Settling the account.
I thought this is the latest thing that Gordon was saying, but then he's not here to defend that.
Right. Well, it's not the accommodating party for
the defendant.
Okay.
You could be accommodating the account. You could even be accommodating the paramount security interest holder. You see?
Remember what Brandon said. The soul of whatever it is you're doing is the object of what you're trying to achieve. What did we put into that trust that's trying to settle this debt? We set the debt account in there. And so the trustee is there for the purpose of settling the debt account. The trustee is not impersonating the trust name. He's trying to settle all of the matters associated with the trust name, which includes this debt. And he had to step in place of the old trustee, which was the name, because he wasn't doing the job. So he is in place thereof, but his job is to accommodate the debt, which is the object of the trust, settle that debt. And remember, the public is military courts, right? And what does the judge or the tribunal on the military court, when somebody appears before the court, what are they most interested in? The rank of the party there. Hi, I'm general. Hi, I'm private. You know, well, who are you? Oh, I'm private. No, I'm accommodation party. That's who I am today. Who am I addressing? She's just there to tell them who you are, or what capacity you're there, so that you can handle the business. They try to trap you into answering for the name. Aha! You are that thing that's in our inventory. Now you're the dead defendant, because that's the thing in their inventory, and you took on the trappings of the name. So the name game is what they trap you into to get you to acknowledge you're the debtor defendant with no remedy, and now you go sit over in the corner, in the dunce corner with the cap, and we'll settle your problems and tell you how many years you got to go to jail. That's the way that's going to go if you play that game.
And so you're accommodating the account, and if you're accommodating for anyone, it's for the paramount security interest holder, because the paramount security interest holder is the one with what? He's got the claim. He's got the claim to all the defendant's property. So it's only the paramount security interest holder who can settle the debt, because it's only the paramount security interest holder who can say, yes, use this property to set off this debt. The debtor doesn't have any right to use the property. You see?
Well, the question standing anyway. The question standing.
The only question standing if you haven't established any, which you do through not only your private process, but through your public process as well, which we'll talk a little more about today or tomorrow or the next day, because you not only have to perfect, and we're going to go through what we call an A, B, C, 3 processes. An A process, a B process, and a C process. The C process is in the public court. And so there's a standing, but how you enter the case is what establishes your standing. So what have you filed? And in what capacity has it been filed?
Well, if you don't file anything,
then you're going to have a hard time getting your remedy.
you don't have any standing.
Well, no, unless you're the defendant.
Yeah.
Because the only people who have standing are the people who have an interest in the account.
That's
the only people with an interest in the account.
But the defendant is a total dead thing with no remedy.
So basically, the accommodation party is also like the intervener too. Is it similar? Or?
Kind of like an intervener in that it's not the debtor.
But you're coming
He's a third-party intervener
affairs for some personal
in order
interest
to
in
assist the defendant, because the defendant is powerless, has no ability to get a remedy.
And is protecting the interests of who? Whose interests are being protected by the accommodating party? The paramount security interest holder.
But he's also benefiting the creditor who brought the claim, and he's benefiting the defendant who ordinarily has no remedy. So it's a win-win.
So Jack, you mentioned this. Does the accommodating party have to be registered?
The accommodating party is actually the grantor, or should have been that grantor to that trust.
Registered on what? What do you mean?
He mentioned that there needed to be some sort of registration for the accommodating party. I thought
one of the
you have to do that UCC1.
Brandon said that UCCs will give notice of what's going on. Now, I'm going to talk about, there's really 3 areas that we want to get into looking at, and we're here this weekend for primarily one area. I'm not going to do that topic right now, but we'll do it this weekend. And you're going to see that there's more to what you ought to be studying and learning than just what we're doing here. Because what we're doing here is we're learning procedures for legal and commercial remedies for things that our straw man and we run into every day. But that's not the sum total of what you ought to be understanding and doing in your life. And we'll get into that in a minute. Before we go on from here, I want to talk a little bit about this birth certificate estate. I don't know if people truly understand what the ramifications of that are. The fact is that your body, in all aspects of what your body produces and gives to the world and itself, is included in that estate. And so let's just say this: everything your body intellectually and physically achieves in its whole life is being dumped into the estate as the property belonging to the estate, not the property belonging to the body. Okay? So if you're registered in the birth certificate and the state, the United States, is the trustee operator of that estate, what rights, titles, and interests do you have to anything anymore separate from the United States that hasn't got everything?
Well, hold on. You have an interest.
You do. But what can you claim for yourself that they don't have a paramount interest in because you gave it to them under no other terms and conditions other than it's dumped into the estate?
Right.
I'm not saying
what are you going to claim
it
through? What are you going to claim it through? You have nothing to make the claim with or through, because the only entities that you're using in commerce are entities that they have control over.
That's the point. Let me put it in plain, simple language. Everybody says that I'm just going to go out and I'm going to make a living. What are you going to do? Well, whatever it is. I'll go out and I'll work at Walmart. But I'm not going to claim it on my Social Security number. I'm just going to take something under the table. But then Walmart won't do that. So you go to some builder and you say to the builder, hey man, I'll be a carpenter for you, but I want to work under the table. What you're really trying to do is claim some kind of commercial interest in the proceeds of your body that you don't want to report back to the United States. Isn't that basically what you're trying to do? But because you entered into the birth certificate estate, didn't you give up all the production and labor of your body to that trust? And so
only under that franchise.
That is correct.
Because there is a way for you to, for instance, if you leave the country and you're contracting and you have no income effectively attached to business within the United States, you have no tax liability in the United States. Why is that? Because you're in a contract that's outside the United States. So you can enter into a contract in your private capacity that's without the United States where there would be no liability. So it's when you're engaged in commerce within the United States, and again, that's not talking about physical space, it's talking about the franchise that you're operating in. And you're working for this contractor who's licensed through who? The state. Mm-hmm. So what's implied there? the franchise. You're operating in your income
franchise.
is effectively connected to business within the United States. So you do have a tax liability to that under the table money.
The point we're making is you can't give it all up and then claim you still have a right to some of it under certain conditions because you gave it all up. We're not saying you don't have remedies. Believe me, we're not saying that. We're just saying that that birth certificate contract, trust, puts you in a situation that you never envisioned in your life. Because theoretically, we've all as living people been paupers. We have no rights to any income. But then has any corporation ever paid you anything anyway other than promises, which are empty? See, they're giving fiction to fiction, which is your trust. They are not dealing with living people ever. But you are so unknowledgeable about what you've done, you've given over all of God's gift to you, your intellect and your physical capacity, and you gave it away to a fiction. What happened in Scripture? In Scripture, didn't God's people always give up their inheritance? Weren't they always giving up their estate? Didn't Esau sell it for a pot of porridge? Didn't Joseph's brothers, because Joseph was the heir for the family estate, sell him into slavery in Egypt? So actually the Pharaoh of Egypt owned the estate of God's people, Israel, which is why they had to go down there and work it off. Everybody is always given up the Lord's gift and blessing to you, to someone else, and we did it through the artifice of the birth certificate scam. So don't go around saying that we Christians are practicing the law of God, because most of us don't understand what's required. Now, actually it was done by mistake and error and lack of knowledge, but Scripture says lack of knowledge is what's getting you people into trouble. And there's ways to reclaim it, and that's in part what we're going to be showing you here this weekend. But the problem is we've all got a problem, and very few of us are understanding the nature of that problem and what we got to do to get our way out of that problem and reclaim our benefits and our rights.
Good. Somebody had the microphone? Go ahead, Bob.
Yeah, Brandy, in order then to function in the scenario that you laid out, there's also the element of the Federal Reserve notes. I mean, you could work under the table, on top of the table, or build tables as long as you're working with lawful money, I guess.
Right.
And then you can find, and outside the United States.
Well, and remember, and I think it would be important that it's expressed in the contract that it is private. Meaning that it's without franchise, without protections, and you write into it a dispute resolution clause. So that the courts, because if you spell it out that the United States never has jurisdiction in this contract, then it's clear. And so it's clear that is your income effectively connected to business within the United States? No. Because the contract's made without the United States. And you've expressed it in every way, shape, and form, including the compensation. Because you're not using Federal Reserve notes in that contract. So I'm a big fan of eliminating ambiguity. You know, so if you're going to write it into the contract, perfect. That's a way of eliminating ambiguity and showing where this contract is venued. But also, silver and gold as the compensation. That's another way to eliminate ambiguity. And yet, another way is for me to put a flag in the upper left-hand corner of my contract signifying the jurisdiction of the contract. And yet another way is for me to state clearly in the language that this contract is sui juris between the parties, in their own right and authority, without any franchise of any political entity. You know, so I'm at every step of the way eliminating any kind of ambiguity that could be construed as something else. That's why even putting in a dispute resolution in there, so that it's known that this can never be taken to a public court for resolution, because that court has no jurisdiction over this contract. And what have we done in this case, in this scenario that we just spelled out? We've taken responsibility, full responsibility. We're not operating under any benefits and privileges of limited liability. Isn't that what we need to reestablish a republic, to be responsible and not be dependent on mommy and daddy to settle our problems for us and settle our contracts for us. We need to settle them privately. And if you start writing your contracts this way and engaging in commerce this way, creating entities under your own authority and contracting with other entities that were created under their own authority, you're taking responsibility and you're taking a burden off the public.
And
you're recreating the republic.
Another way, in addition, is at the end of the accounting period, just privately redeem the public use. Everybody should go to 12 U.S.C. 411 and 31 U.S.C. 3113. And at the end of the accounting period, why do you have to use Federal Reserve notes in your commerce?
It's all that's available.
It's all that's available. Why is it the only thing that's available?
Because they took all the substance.
Because in the military takeover, they took all your substance and they gave you military war script. Why did they only give you military war script? Because they have to track your activities to make sure you're not terrorists. So that works. They can force benefits, privileges on slaves, right? Can they force benefits on privileges on responsible people? No, so they have to give you a remedy to redeem. So under 12 U.S.C. 411, isn't 12 U.S.C. banking? Do the Federal Reserve notes come through the banking clauses? You bet. 12 U.S.C. 411 as opposed to 911. Under 411, they give you the right to redeem your dollars, Federal Reserve notes, dollar for dollar. Did you know that?
411 happens to be information.
Yeah, 411 is information. It's very valuable to you, too. Okay, so you can redeem your notes dollar for dollar. Where do you have to redeem them? With Treasury in the District of Columbia. And if you go there and take your dollars for redemption, what are they going to give you? On the public side, they're going to give you more Federal Reserve notes. What if you tried to do it on the private side? What would you do? Would you exchange dollar for dollar Federal Reserve notes for $1 of your asset funds in your asset account? Is your asset funds the equivalent of lawful gold and silver money? Yes. So if you ask them to redeem your public liability to compensate by your private set-off, are you really taking a benefit anymore? No. Now under 31, section 3113, 31 is the number of offspring. It's God's people. And 3113 is a mirror image. 13 is Israel. 13 tribes. What are they telling you there? They're telling you that the Treasury will take a gift in order to set off the public debt. So let's say your straw man had $100,000 of Federal Reserve note use last year, right? And you want to redeem all of those Federal Reserve notes for your asset account funds. So if you file the 1040 return, is that directed to the Treasury in the District of Columbia? Well, that's where you got to go to redeem, isn't it? Because isn't Internal Revenue a sub-agency under the Secretary of Treasury, U.S.? Private international has nothing to do with U.S. government. It's private international. So when you file a 1040, 10 is law, 40 is probation. So the law of probation is give up your beneficial use of dollars and substitute 100% of your asset funds out of your account. And now you're not using a public benefit anymore, but you're not throwing your good stuff into the public. You're using the Federal Reserve notes like everybody else. But at the end of the year, you're setting them off dollar for dollar. You're redeeming them out of your asset account. And then after you've exchanged them for lawful money, didn't your straw man last year spend all $100,000 into the public economy, creating more public debt? So when you redeem it dollar for dollar, just gift it back to the Treasury to take care of the debt that your straw man left. You've wiped your slate clean. Everything your straw man took in last year was no longer a benefit. It was actually responsible exchange, and anything your straw man acquired in the marketplace, you've got legal title for now because you know how to redeem it. There are so many ways of getting your remedy. All you'd have to do is understand what you're doing. And in essence, you're filing a tax return every year as a creditor instead of filing a tax return every year as a debtor. And if you redeem the whole sum of the money that came in on your federal tax return last year, then did you have to pay any federal tax last year? No, because there was no beneficial use. So even if your straw man is working for a corporation, can he file his W-4 claiming total exemption from withholdings for federal tax next year? Absolutely, because there was no tax liability this year, and we're not expecting one next year because we're redeeming all of the dollars, dollar for dollar. If you people only understood the remedies you've got in place, if you know who you are and what's going on, you could take this planet back in a heartbeat. Okay, we're supposedly out of break. Is that true, boss?
That's correct.
Okay.
Yeah, 5:30.
Go out in the playground.